My name is Skipper Maurice Strauss. I'm with the Sunrise Law Group. I would like to talk with you this morning about estates and about how to access a checking account when a person member has deceased, and how to obtain title to immovable property or other property in the estate. Now, Louisiana in general is a state that requires a succession or probate. Those two words are pretty much interchangeable in this state, but it can happen in two particular ways, again, in general, and one being through a last will and testament, and the other being what's called intestate, which is without a last will and testament. I'll talk to you first about with a last will and testament. When a person dies in the state of Louisiana, and they have a bank account, that bank account is generally frozen. So the heirs cannot get to it until an estate is open and some person or entity has the authority given by the court to access that account. So what you have to do is open that succession. Most last wills and testaments call for an executor, executrix, or administrator, if you will, and that person is appointed by the court, and he is then authorized to act on behalf of the estate. There are some other particular rules that go with that, such as obtaining a tax ID number and other things, but in general, a executor or an executrix is appointed to represent the estate, and they can proceed to get those funds on behalf of the estate, so the estate can move forward with whatever they need to do to place the heirs in possession or title or ownership of the property. The other way, of course, is an intestate succession, which is when a person dies without a last will and testament. And at that point, you have to decide one or two things. Is it practical to have all the heirs placed in possession of the property, which means they will all be equal owners and according to their percentage, and then they can all jointly move, or have all of the heirs agree to appoint an independent administrator, and that person can move forward. Quite frankly, it's simpler if there are a lot of heirs to appoint someone so that person can act in good faith and with a fiduciary responsibility, I might add, to the other heirs, to get this estate moving forward and obtain title to the property. Because some people seem to think that when their mother or father dies, the title will automatically pass to them, especially if they have a last will and testament. That, of course, is not the case. A succession or a probate proceeding has to be open and move forward and ultimately closed for the heirs to get title to the property. This is general information, and if you have any questions at all, we would be glad to assist. Just give us a call. Thank you.